Welcome to today's video in which I will be analysing my answer to the Dan question. If you haven't watched the last video, then I suggest you watch the last video in which I show you how to plan an answer to this question. I'll leave a link to the video down in the description. If you've come from the previous video and you haven't written an answer, then I suggest you take 20 minutes out, you quickly write an answer using your notes, and you come back and watch the rest of this video. For everyone else, let's analyse the answer. Most of my intros follow a similar pattern for my negligence answers. I start off by saying for the claimant to have a successful negligence claim against the tortfeasor, he must establish that the tortfeasor owed duty of care and that he'd breached the duty and that the breach caused the damage to the defendant. Then I go into duty of care. Then I talk about a duty of care. This is all just repetition of everything I've used before. Explain Robinson v. CC West Yorkshire, what the Supreme Court said. This is all what I've memorised. That's nothing new. Here's where I start my AO2. Dan bought food from Chris, the owner of a fast food stall. He got ill from it and spent 2 weeks in hospital. If the case Robinson was applied, the past precedent should be followed is Donahue versus Stevenson's, whereas decided tortfeasor, the manufacturer, owed a duty of care to his consumers. There's a bit more AO2 stuff for Donahue versus Stevenson. Sorry, AO1. So here, a bit more AO1. Therefore, Chris would owe a duty of care to Dan as he is proximate, and it is reasonably foreseeable that harm may come to him from the food they are selling, especially if it's stored in an unhygienic room for a long period of time. So let me just highlight AO2. So talking about applying Donahue versus Stevenson's part of AO2. And there you go, that's AO2. Breach of duty. A breach of duty occurs where the tortfeasor fails to meet the standard. Okay, yeah, so this is also repetition of what I've memorised. I've just parrot learnt this. Textbook answer for Blythe v Birmingham Waterworks for breach of duty, and then Bolam v Fyan. So I'm just going to highlight that. That's your AO1. So up to here is your AO1. And then going to AO2. Therefore, in this case, Chris would be judged by the standard of care. So Chris would be judged by the standard of care. Other fast food owners. First point for your AO2. Standard of care is objective. Wouldn't really call that AO2. Hence, Dan becoming seriously ill from the contaminated food is a highly likely breach of that duty of care, as professionals from that body shouldn't be selling or storing contaminated food. There you go. I'm applying what I've said already. In the AO1, I said that they're judged by standards of other qualified professionals of the same body. And here in the AO2, I'm comparing Dan to other professional bodies. I'm applying this AO1 here onto the scenario here. Then AO1 again, judges also take into account risk factors to establish if the duty has been breached. So that's also just memorised here in AO1, and then I apply the AO1. In the case, risk of selling contaminated food that's infected with bacteria is great, as it can cause people who consume it to be seriously ill depending on level of bacteria. That's just AO2. Showing that if the risk is great, then the precautions needed to be taken also need to be greater. And here, Chris hasn't taken proper precautions. He hasn't taken greater precautions, even though the risk is great. And I've explained how the risk is great, so that's an AO2 mark. So another risk factor, potential seriousness of harm. Once again, this is a bit I've memorised. Potential seriousness of harm, underlying condition. That's Paris v Stepney Borough Council. So, and then it said Dan had a weak immune system. Doctors said this. But then I said it could be argued that in the case, Paris v Stepney Borough, the employer knew that the claimant had a physical condition, whereas Chris didn't know that Dan had a weak immune system. And this is what I said in the previous video, counter arguments. What could the defendant, or in this case, the tortfeasor, what would you try to argue back, including that at the end of your paragraph? A short one would give you an extra mark, and it shows that you are fully applying your legal principles, and that's what you need to get to the level 4 band. It needs excellent application of legal rules to the given scenario, excellent presentation of a legal argument which is accurate, fully developed and detailed. You need to get it fully developed and detailed. And you need to use appropriate legal terminology as well. So just throw in a couple legal terminology like tortfeasor, claimant, instead of using defendant. Definitely don't use prosecution because that's straight up criminal law. Okay, on to the next paragraph. Another relevant risk factor that would be assessed is cost and practicality. To prevent harm, it's measured against harm. If cost outweighs harm, then the defendant wouldn't be liable, like in the case Latimer v. AEC Ltd. So cost and practicality, defendant needs to take reasonable precaution in proportion to the cost and practicality. But in this case, Chris hadn't taken any precaution that went beyond cost and practicality. Nothing that we know of, nothing was told in the scenario. Food could have been checked. Here I'm going into more detail. It could have been stored in a hygienic place, in a more hygienic place. I'm assuming it wasn't stored in a hygienic place, hence it was contaminated. Come back with the argument. It may be argued that it could cost the defendant more to hire more workers, and it would be impractical to make them work longer shifts to clean the place proper. But then I gave my overall conclusion. I don't think the cost would outweigh the risk of harm, and therefore he'd be in breach of his duty of care. And that's all a lot of AO2 right there, which is worth a lot of marks. And then again, breach caused the damage. Quick explanation of what breach is. It's the 3 tests: factual causation, legal causation, remoteness of damage, assessed by the judges. And then factual causation, I explain what factual causation is. And then I use the case Barnett v. HMC. And then the AO2. Apply AO1 onto the scenario and you've got your AO2. So Dan wouldn't have ended up, okay, that's the but-for test. Boom, straight away, there, 1 mark for your AO2. Next one, legal causation. If there are any intervening acts that broke the chain of causation, I'd say this would be worth them remoteness of damage. Once again, the AO1 should already be in your head. You should really spam that down as fast as you can so you can make room and make time for the AO2. So you can apply the AO1 onto the AO2. So I'll explain here what the what remoteness of damage is. In this case, the type of harm was foreseeable as the food was contaminated. It was foreseeable that Dan will become a bit ill, but it wasn't foreseeable that he would become seriously ill and would go to hospital for 2 weeks. But that doesn't matter because of the case Smith v. Leach Brain decided tortfeasor must take victim as he finds them, thin skull rule. And I've done Bradison v. Robertson Rentals as well, more extensive damage. So there's a bit of an AO1 in the middle there. And then in this case, Chris would be able to, and then straight away to the AO2. Chris could foresee some harm. He could foresee some harm, just not all of the harm. And it was obvious that Dan would become a bit ill, but he couldn't foresee the extensiveness of Dan's injury. So hence, damage isn't too remote, which means all 3 tests have been passed, and therefore the breach has caused the damage. And then a quick conclusion. Now, for an answer this long, I don't see any criticism apart from that this answer is way too long and you definitely won't be able to, well, you probably wouldn't be able to write an answer this long in the exam. But if you actually look at the answer, it's mostly filled up with AO1 marks, and I probably didn't need to do this much for AO1 because they can only dish out 8 marks for AO1. So what I advise is memorize your AO1 because that's really important. And inside your AO1, because you've memorized it, you can include your technical vocabulary, your legal terminology, and that would help. That would definitely help boost your marks for AO2. And then you also want to make sure when you memorize your AO1 that it's fully developed and detailed. Your answer would stand out compared to the other answers. They can see that it's been more fully developed and detailed. And if you use a lot of legal terminology in your AO1, you could also incorporate that into your AO2 and then spread it out throughout your answer. And that way, your answer would look a lot more consistent, and you could definitely get into level 4, if not top level 3. So that's the end of that. We've analysed the answer, and now I have a perfect model answer that I can use for a bunch of other negligence 20 markers. So I hope this helped. This should have definitely helped, and I'll see you in the next video. Bye.